I mean, obviously staff is very concerned about how long this is going to take. That's why they want to sort of trample over due process rights. Well, clearly staff is ready to go, must know where it's headed in terms of what curtailment orders are going to be issued, where, when, and how. Well, let's put that on the website. Let's release that now. I'm sure that staff is not going to wait 30 days to figure out what it's doing, because that would defeat the whole purpose of, or 60 days, it would defeat the whole purpose of having a regular due process hearing. So I would request that you consider just putting it all out there for discussion, so that some of the, what's been said before, some of the folks that are subject to curtailment may be able to put their heads together, figure out an approach or a strategy, rather than just waiting and going through this process and everybody knows what's going to happen in 14 days. Let's put it out now. Who's up first, where, when, and how. Thank you.
Thank you. Jennifer Spalletta, followed by Karen Magliano.
Good afternoon, Chair and members of the board. Thank you for the opportunity to provide comments. Jennifer Spalletta, I'm an attorney. I represent a variety of landowners who have a variety of different kinds of rights, permits and licenses, as well as pre-1914 and riparian. I share the concerns that have been raised by particularly Mr. O'Loughlin, Mr. Manazian, Ms. Salesi, Mr. Reese. I think they've all raised very good points, and I even share Richard Roos Collins' list of questions that were posed that he believes staff should answer. This is a proposed regulation that essentially delegates all of this board's authority regarding curtailment to the deputy director. It is an extreme version of delegation of authority. There are two requirements under the law for when a delegation of authority is valid. One is if it preserves procedural safeguards, which verifies separation of powers of the three branches of government. That is why the due process issue is so critical. If you do not have adequate due process in the regulation, it will be immediately void under the delegation doctrine. And that's something that you need to understand. Adopting a regulation that is so controversial on the due process issue will simply mean there's going to be litigation over the issue. You are not going to achieve what you want, which is curtailment and satisfying protection of senior rights. The second thing is fundamental policy issues may not be delegated. We have had a fundamental policy issue discussion today, which is evident, and that is the ability of riparians to continue diverting in the latter part of summer when the water in the channel is a mix of what would naturally be there and releases from storage. You need to have an evidentiary hearing on this issue. This issue is a difficult policy issue. You have law that was established in a California Supreme Court case in 1858. It's the Butte Canal and Ditch Company case. The law was codified when California became a state in the civil code and is now found in Water Code section 7075. The law is very clear that when someone who stores water wants to release it into a natural channel and pick it up later on, they have an absolute right to do that as long as it does not impact the right of the existing diverters in that natural channel to continue their diversions. So you have to be able to find that riparians in the Delta would not have water available for diversion if you want to try and protect this stored water that's moving through the Delta. Because all of these diversion pumps are below sea level, I think it begs the question, has there ever been a point in history where there was not water at the pumps? It's a serious evidentiary question and policy issue that should not be delegated and should be decided by this board. The final thing I want to hit on is if you were to make a decision after an evidentiary hearing, it would be immediately appealable to a court of law. There would not be a requirement to exhaust administrative remedies. As written by your staff, these regulations actually defray a court's review of curtailment. They actually extend the time period to the detriment of a diverter. Because under the Water Code, if the deputy director makes the decision, there is an exhaustion of administrative remedy requirement before you can go to court. If you make the decision, you can immediately file a writ. So if you want to know that you're making the right or wrong decision, the decision needs to be made by you, because then the court will quickly be able to review it. If you do what the regulations say, a court will not be able to quickly review it, which is extremely problematic on the due process issue. Thank you.
Karen Magliano, followed by Chris Shearing from Farm Bureau. Ms. Magliano from the Air Resources Board.
Good afternoon. Yes, my name is Karen Maliano, and I'm with the California Air Resources Board. And I appreciate the opportunity to speak briefly this afternoon about some of the air quality aspects of the health and safety exception. And as we know, exposure to particulate matter is a significant health concern, and as a result, US EPA has established federal ambient air quality standards for PM10 and PM2.5. Mitigation of fugitive dust is a key element of programs that many local air districts have in place to be able to meet those air quality standards. And their rules and regulations address a vast variety of different kinds of fugitive dust sources, from agricultural operations to unpaved roads and construction activities. In most of those rules, though, they do outline a variety of different methods that you can use to reduce fugitive dust emissions, though in many cases, water can be one of the more effective uses. But recognizing that we do have reduced water availability, air districts, including the San Joaquin Valley, have been doing a great deal of outreach to their stakeholders to help them look at other methods that they can use and still meet those air quality rules. As you saw this morning from the table that was shown in the staff presentation, to date, there have not been any requests to address the health and safety exception in the existing regulations. However, we know with the ongoing drought, we're really in uncharted territory about what some of the impacts might be. And so we do feel it is appropriate to consider keeping some kind of mechanism to potentially be able to address what might happen. But we've talked with staff about some additional language changes that might help better focus that potential health and safety exception to really deal with the concept of more of an emergency kind of situation.
An
where there
acute
might be
risk
more
rather than a
imminent
long-term
type
risk,
of
right?
risk, rather than just the ongoing
Right.
air quality problems that we do know exist.
Thank you.
Thank you.
Thanks. Chris Shearing, followed by Bruce Burton from the Division of Drinking Water.
It's been a long day already. Good afternoon, Chair Marcus, members of the board. I am Chris Shearing. I follow water issues for the California State Farm Bureau, in addition to which my family is a riparian water right holder, and yes, we have received one of your notices, so this is not strictly a theoretical for my family. The Farm Bureau has submitted written comments to you. I'm not, as part of a larger ag coalition, I'm not going to reiterate all of those. I will say that the staff presentation this morning was lengthy and helpful for that reason. I don't want to reiterate some of the many comments that you've heard so far today, but I do want to hit on three key areas. Before I do that, I want to compliment the chair for a couple of times today saying that your job today is to uphold the seniority system or the priority system. I really hope that that's what we're here to do, because that's something that my members can understand, and that is something that I can articulate to them as the basis of California water rights law, at least with respect to surface resources. My three main points with respect to the proposed regulations would be, first, the hydraulic information you heard from Mark Van Camp. I would certainly urge the board to take a very hard look at that to find out if it is true that the system is in equilibrium, as David Guy said, with respect to the pre-14s and riparians. If that is true, it would certainly be nice to avoid some messy jurisdictional issues about the pre-14s and the riparians. There's been a lot of talk about that. We at the Farm Bureau do not believe that you have final regulatory authority over pre-14s and riparians. That's a legal issue for the courts, I suppose, but we don't think SB 104 gave that to you. We also don't think that the Light decision or the Young decision gave that to you. We think that you have some amount of authority to stop unauthorized diversions and waste and unreasonable use, but we don't think that that completely subsumes the field of final authority in regulating pre-14 and riparian rights. So any means to avoid that thorny jurisdictional issue would certainly be right, and I hope that no stone goes unturned on the physical necessity for any curtailments you may be considering in that regard. Due process. I don't want to beat the dead horse on due process, and it even feels like a dead horse to me at this point, but it's keenly important to our members. Due process is fundamentally a guarantee that government work that is not done correctly won't hurt important rights of individuals. It's no small matter. It should take solid staff work, and it should take deliberate action to curtail a water right. I believe that because I know a lot of people that farm, and I was put through college on farming money that was underpinned by some ability to irrigate. So these are important things to people out there, and due process is no joke. I think it's particularly important with respect to your database on pre-14 and riparians, which is admittedly not very good. I think talking about streamlined enforcement mechanism that could affect those guys is probably the exact opposite direction of where we should be going. It looks like my time is out, so we have the other concerns that have been expressed about the ability to have a hearing. Is it discretionary? Is it the first time I'm going to have a hearing for sure in court? Let's deal with that. Immediately enforceable curtailment orders, that's a new one for our guys. I won't go any further. The last thing I want to hit, if you'll just suffer me, is the health and safety exception. The Farm Bureau is not here for the proposition that people shouldn't have their immediate health and safety needs addressed. Drinking, running the dishwasher, taking a bath, putting out the house that's on fire. They don't fit into the water rights system, but we're not going to stand here and argue against that. We do think that the health and safety exception should not be a substitute for devices like transfers go by the water. It should not be a substitute for sound planning by the urban water agencies. It should not be a substitute for mandatory urban water conservation. And I do have to follow up on Member Diadamo's point, which is that dust control, it seems to me that fallowing large amounts of ag ground to provide water for dust suppression is a little bit of trade one thing for the other. So bottom line for us, please don't adopt the regulations. This conversation is coming too late in the year with too many things to figure out. It's July 1st. Do your best under your existing authorities, and that's all I have. Thank you.
Thank you, Mr. Sheeran. Bruce Burton, followed by Thomas Birmingham.
My name is Bruce Burton. I'm Assistant Deputy Director, I guess, in your brand new drinking water division as of today. I want to thank the board members for the opportunity on my very first day as a board employee to attend a full board meeting. It's been instructive.
I would like to tell you this is typical, but it's not.
I'm sorry, I didn't hear you.
This is not typical. Although it's getting more typical all the time, but that's a good thing that we're listening to everyone.
I'm here to address one issue in the proposed regulation, and that is the inclusion of a exemption process for basic health and safety needs. I have a statement to read about the division's position on that. In early June, the board adopted a set of emergency regulations that included an emergency exemption process for health and safety, and in that, I just want to quote from that. The regulation states that given the essential nature of water in sustaining human life, use even under a more senior right for any other purpose when domestic and municipal supplies required for a minimum health and safety needs cannot be met is a waste and unreasonable use under the California Constitution. As a result of the board's feeling on this, they adopted the exemption process for health and safety, minimum health and safety requirements. The division believes that this exemption process is absolutely essential to the protection of public health. Public water systems that have sources with junior water rights that have no viable alternative sources or no current viable alternative sources could be forced to cease operation to their customers within a few days of receiving a curtailment order. This would result in a depressurization of distribution systems and a lack of sufficient water to meet basic health and sanitation needs, such as drinking, cooking, human waste disposal, and bathing. In addition to the real public health hazards as in depressurizing a water distribution system and introducing contamination into it, which could result in public health or waterborne illnesses, these conditions would really cause hardships for the people who live in those communities. The exemption process you all adopted for the Deer Mill and Antelope Creek has severe restrictions. I've heard today several people allude to this exemption process as possibly letting water systems off easy, but that's not the case. The restrictions include mandatory conservation measures limiting the amount to 50 gallons per person today, and a mandate through a submitted plan to find other sources. So one thing we might suggest is to satisfy critics of that is include some type of process to revoke that exemption, that exception, and you would probably want to work with your new Division of Drinking Water staff who are out in the field and know these systems intimately and are going to be working with them anyway to make sure that these systems comply. The divisions of water rights sent out a health and safety claims form to junior water rights holders, and the latest report I got that 28 of those systems, 28 water systems submitted that form indicating that they had no other viable source. One of these is a system in Lake County, Hidden Valley Lakes Community Services District, that serves 6,000 people. They have 3 wells along Cache Creek. They have a water right for underflow, but they have no other current viable sources. They do have a large recreational reservoir that they may be able to use to refill the stream or actually treat, but right now, both those options would take time, and if they received an order, they would be in violation. Another system is Rain Creek's Water Company in Sonoma County. They take water from a single well, underflow of the Russian River, serve 230 people, and they do have no other viable alternative. Now, they too may be able to buy water from a senior water right, probably the Sonoma County Water Agency, but that too will take time, and if there is no exemption process, they will be in violation right when the order is issued and have to make the choice between continuing to divert and supply their customers or being in violation. The division agrees with the principle that the board has adopted that domestic and municipal use for basic health and safety should be the highest priority for drinking water in the state of California. Without the exemption process, the real possibility exists that public water systems being unable to provide their customers the water to meet basic sanitation needs and the resulting public health hazard. In light of the severe drought we currently find ourselves in and the possibility of dry weather continuing in the future, we believe it's important for the board to state clearly that domestic use to meet basic needs is the highest priority for water in the state, and we believe that that exemption should be in this regulation if it's adopted.
Thank you very much,
Thank you.
Bruce, and welcome. Mr. Birmingham, and then we need to take a short break for the court reporter who's been heroic,
Thank you.
and then we'll come back.
My name is Thomas Birmingham. I'm the general manager of Westland's Water District, and I'm here to express Westland's support for the adoption of the regulations. Before I begin, however, I'd like to make a couple of observations. It's been a number of years since I've appeared before the State Water Resources Control Board, and I'd forgotten just how entertaining Mr. Nomalini and Mr. Herrick can be. The other observation I'd like to make is I heard Mr. Nomalini complaining about the commingling of project water with water that otherwise would be in the stream systems from which his clients divert. And I interpreted that to mean that Mr. Nomalini is supporting the governor's proposal to construct isolated conveyance facilities, which we applaud. We appreciate the support. But the...
It's just like the old days. isn't
Just
it?
like
Yeah.
the old days.
Right.
But by expressing support for the regulations that the board is considering, I don't mean to suggest that there aren't some very legitimate concerns that have been articulated here today. As an example, the Northern California Water Association has expressed concern about curtailing pre-14 appropriative rights in order to support diversions in the South Delta. There are 2 different watersheds, and so NACWA has a very, very legitimate point. You've heard concerns expressed by agencies on the San Joaquin River, and you've heard concerns about due process. All of the concerns that you've heard, however, go toward how the regulations would be implemented, as opposed to whether the regulations should be adopted. The basic question is, are we facing a circumstance, an emergency circumstance, that warrants deviation from the normal procedures that the board follows? And from our perspective, the answer to that question is yes. We are facing water supply shortages that are unprecedented. I greatly appreciate the heart-tugging comments made by farmers from the Delta, but I've observed farmers doing exactly what those farmers are afraid of, tearing up permanent crops because the farmers don't have adequate supply. I have reviewed the regulations and have interpreted the regulations as an attempt to protect those farmers. If in fact those farmers have riparian rights, then these regulations would protect the ability of those farmers to divert water. The regulations appear to be simply a statement that the board is going to enforce basic principles of priority. There are lots of questions that have been expressed about unknowns concerning dates of priority for pre-14 rights. The reality is, if the unimpaired flow in a stream system is insufficient to meet the needs of riparian water right holders, then there simply is no water available for appropriation. And that's a relatively easy determination to make. A comment has been made, well, no one is complaining about, no senior water right holder is complaining about the diversions of others. That's because the state project and the Central Valley project have been providing water that diverters have been taking without a right. And as soon as you tell those diverters you need to cease the diversion of project water stored and released for project downstream purposes, there will be many complaints about how pre-14 appropriators are depriving legitimate riparian users of the natural flow in the stream to which those riparian users are entitled. There are lots of very legitimate concerns that have been expressed, but again, those concerns go to whether or not, or how the regulations would be adopted or implemented, not whether they should be adopted. Mr. Lilly made a very good suggestion: amend the regulations to provide that any curtailment order that's issued pursuant to the regulations will end at the end of this water year on September 30, 2014. Ms. Zalesi raised some very legitimate concerns about due process. And I would not profess to be an expert on constitutional law, but my understanding is that due process is determined by the circumstances of an individual case, and in exigent circumstances, the process that may be due is not the same process that's due under all circumstances. Now, that doesn't mean that there can't be, that you can avoid the obligation to provide notice and an opportunity to be heard, but again, my understanding is that it is a three-part test under applicable constitutional law, and that the first question is, what's the scope of the harm of the affected party? Here, the scope of the harm is potentially great. What's the likelihood that the procedures will result in error? And I think that question is subject to dispute. And then finally, what's the compelling interest that warrants deviation from the normal procedures that the state board would utilize? And here, in the extraordinarily dry conditions that we're facing, the interests of the state in enforcing its water right priority system is very, very compelling. But to address the concerns that Ms. Zalesi raised, it would be relatively easy for the state board to direct staff to include in the regulations that reconsideration shall be granted, and that during that reconsideration, an individual diverter that has received a curtailment notice will be given an opportunity to submit evidence concerning their right to divert water. But again, these things go to whether or not the regulation, or how the regulations would be implemented, not whether they should be adopted. And given the exigent circumstances the state is facing, we would encourage the board to adopt these regulations. Thank you.
Thank you. Now, we'll take a 10-minute break, and then we'll resume. Hopefully that will be enough. We will be going late, so I hope that's all right. I don't know. Let me see.
Talk to him for a month.
Greg, yeah. You figured it out yet?
You know, I figured, like everybody else. All right, good stuff. Thank you.
Mr. Gowdy.
Valerie. Good, how are you?
How's it going?
Oh, gosh. It's like a fire hose. But, you know, it's kind of,
Feeling fire.
yeah. Well, it's, as an engineer, you know, a lot of this legal stuff is my territory, but really fascinating.
I know. Well, I know. Very fascinating. And you know, I feel bad. You know,
Well, it's, you know, it's really kind of interesting to sit back and look at this sort of philosophically. This is what makes our country so great, is this ability to hash out your concerns and have the right to that sort of process. Yeah, yeah, and it's painful, it's long, but it's fundamental. Yeah, likewise. This is a good idea. I was just telling Valerie, as an engineer, a lot of this legal stuff is outside of my expertise, but it's fascinating. It's really at the core of
This is one of those marathon events.
legal theory. It'd be interesting without him. Yeah, right. Oh, there you go. Wow, I didn't think about that.
Janine, can you do that just so I can call people to order? We'll be reconvening in just a minute. If you could take your seat. Okay, thank you. Our next speaker will be Michael Warburton with the Public Trust Alliance, followed by Chris Schutz from CSPA.
Afternoon. I'm Michael Warburton. I'm executive director of a nonprofit. No likelihood of a profit here on any horizon coming up. This whole day has reminded me of how interesting it is to live in a community where reasonable minds can differ. But it's not automatically a reasonable situation when you have people following their reasonable interpretations of the universe to the exact end that they have. And first off, I'll say that our organization is very much in support of the adoption of emergency regulations. And in a couple of ways, too, because it is actually time to do something. Board process in the past has been done on the basis that as long as you don't do anything, it keeps working. And, well, due process has come to be understood in sort of that level. But this drought, in the emergency regulations, you say, hey, we've got to find out what we're dealing with. Because the information, just the scientific information on the situation that we're in is incomplete and uncertain. And it's because it's been that way from the very beginning. Claims were made in the 1850s, 1860s to more flow than was ever in some of the stream systems. And okay, let's be realistic. What are these riparian and pre-1914 rights? They're all over the place. And the holders of them don't even know what they are. So, and the thing is that there are more rights than there is water. And, you know, by factors. And it is reasonable that curtailments are going to have to be done. And one thing that's interesting is this is all our water in a very basic sense. And the Water Code has made that clear, that this idea that there are sort of religious icons of vested property rights is not the case, and it has not been the case historically, even though some people might want to believe that. And the thing is, we're also dealing with an actual drought and climate change. Sea levels rising. And how much of saltwater intrusion is due to the rising sea level and how much is due to overpumping or over-withdrawal? You can't just forever say, oh, there is equilibrium, and the situation is changing, and California is going to have to adapt to it. And it's really good to have a commitment to reasonableness and transparency in terms of how decisions are being made and on what basis that they're being made. The thing about due process is that, as I looked around today, I don't see a single representative of a native tribe of California. Now, when we talk about first in time and first in right, there are people who are alternatively laughing out loud and crying sobs about what this first in time, first in right means and what due process means. Yet those people are going to be in our community as we move forward, and I think the board is taking a very reasonable approach to moving forward with a full community. And the Public Trust Alliance is sort of founded on the principle that there is a public trust and that it is incorporated in water law. And you know, there's priorities too. There are priorities. And the California Supreme Court did say that there is continuing supervision that has to be done on these rights and that they are adjusted in the face of changing scientific situations and changing public values. And anyway, what we want to do is to say that we support the board in actually responding to a drought crisis with a reasonable framework of how to start doing something. And we look forward to membership in this community.
Thank you, Mr. Warburton. And next, Chris Schutz, followed by Julianne Phillips from the San Joaquin Farm Bureau Federation. Hello, Mr. Schutz.
Hello. Good afternoon, board members, Chair Marcus. I have a little statement from Mr. Jennings, and I have a couple of comments of my own. Yesterday, the USDA issued a forecast for the almond production in California. It's forecasted at being 2.1 billion, as in B, meat pounds from 860,000 trees in California. This will be up 4.5% from last year's crop. Clearly, almonds are not endangered. The California Department of Fish and Wildlife recently posted the results of Survey 7 of the 20 millimeter Delta smelt trawls conducted early in June. Unlike almonds, Delta smelt are in serious jeopardy, and this year's numbers are the lowest that we know of. Only 24 smelt were caught in 141 trawls at 47 stations during Survey 7. Almost all of them were in the West Delta, where they can be exposed to lethal temperatures. Smelt were hammered in last fall, and the fall midwater trawl abundance was statistically insignificant from the lowest on record. They're going to be hammered again this year. We've noticed with interest the increase in Sacramento River flows. The gauge at Freeport shows tidally filtered flow was about 10,600 CFS over the last week. It's clear the projects are having trouble maintaining salinity levels. Clifton Court is above 700, and Old River EC, that is EC, and Old River EC is pushing 1,000. The Bureau reports an average net delta outflow index of 5,588 CFS over the last week. CSPA questions the accuracy of the NDOI, but if inflows to prevent salinity intrusion are actually in the range of 5,000 CFS, additional reservoir demands or storage demands will be in excess of 100,000 acre-feet per month over what was projected. Exports in the range of 1,500 CFS would deplete another 90,000 acre-feet of storage. This loss of cold water storage will likely result in a near-term disaster for winter run and fall run this fall. Those runs were hammered last year. So, stored water must protect public trust resources. We fail to understand how the board can sanction the export of limited reserves of stored water to the most junior water rights holders, while failing to protect public trust resources, turning the priority system upside down, and curtailing the use of water in area of origin. This is an unreasonable use of water. If the board is not going to adopt Mr. Herrick's proposal to use San Luis water to maintain water quality, we'd like to know how the board plans to keep water in the San Joaquin River this year. Can I have a couple of minutes?
Just go, have a minute.
Personally, I find it fascinating that we now have a call from the water user community for good measurement and real-time data and good process. This is the water community that collectively has sought to limit information, certainly of individual diversions, and has also objected to the idea that the water rights, Division of Water Rights, should be able to charge water rights fees adequate for it to do its job. And I like the idea that Mr. Van Camp put forward about improving the database and all those kinds of things, and having good data and reliable information on which to work. But I think we have to understand that what's happened here is that we are caught out, or the board is caught out, in really not having a system that it should have. And this is not going to be solved in the short term. The board needs to do what it can with information that it has, but we shouldn't forget this. And it's going to involve a lot of effort, it's going to involve a lot of staff, it's going to involve a lot of technical support, and a lot of money. I do find it a little disingenuous for some members of the water user community to suggest that we don't have the information that we need in order to enforce a rule, when what's happened in the past has been that they haven't really supported the kinds of technical and innovation and the kinds of reporting requirements that would allow this to be more meaningful today. So if anything comes of this, let's all support counting the water and reviewing the counting and auditing the counting and enforcing the law. And let's have technical support that's worthy of the 21st century. I do disagree with the idea
Right, and
that you can
this
mix.
should be your wrap-up.
I'll wrap it up. That you can mix the technical question with the legal one, particularly about how water is being used in the Delta. That requires a full evidentiary hearing, and you should not do that now. I agree with Ms. Spalletta that if you're going to deal with this, you have to deal with it in a more formal and thoughtful, long-term way. In the meantime, the law is that the projects are required to support Delta water quality. And any effort that you make that might seek to change that in order to enforce emergency regulations would be something that we would very strongly oppose. Finally, someone
Right,
said
and
it shouldn't be
really
easy.
finally.
Really
Sorry,
finally.
just 'cause we're getting late.
Someone said it shouldn't be easy to destroy businesses. Well, I could just not help but thinking, as easy as it is, for example, to violate water quality standards or to destroy fisheries, good process needs to go for all, and not just water users who are worried about what's happening in the very short term. Thank you.
Thank you. Thank you. All right, Julianne Phillips, followed by Jasbir Nihar.
Thank you, Chairman Marcus, members of the board. My name is Julianne Phillips on behalf of the San Joaquin Farm Bureau Federation and the 4,000 family farmers and associate members that we represent in San Joaquin County and parts of the Delta. Before I get into the meat of the matter, I need to address how incredible it is that we're even here discussing the curtailment of pre-1914 and riparian rights today when you have only 30% compliance with your post-1914 curtailment notices that went out last month. One of the first points that I'd like to address, you're right, these things really, it's not natural talking to them.
Really, you got to pretend you're a rock star. It's not a normal thing to do.
One of the first points that I'd like to address is that these proposed emergency regulations have been referred to as a flexible regulation, which is an oxymoron in and of itself. What that means to us is that it means there's no easily identifiable process by which you will begin sending curtailment notices out, and it's completely within the discretion of your deputy director. That seems to be an overreach of the discretion of the deputy director, and it's not transparent for the people who are going to be curtailed. They don't know when these are coming, they don't know when to anticipate them, and they don't know in what order. Secondly, the hydrology that your staff intends to rely on when they send these curtailment notices out has been characterized as a crude tool. And sometimes those crude tools become very violent weapons, and that's the instance here. You heard from staff today that they want sufficient detail, but they don't want to get bogged down in the details. But when you're talking about somebody's livelihood, cutting off their water, their ability to farm, their ability to provide for their family and their employees' family, you need to get bogged down in the details. It needs to be very thoroughly vetted, and you need to know exactly how much water is available before you start telling people there isn't water available for them. Secondly, the one thing that we need to talk about, but I'm not going to beat this dead horse because I don't think anybody wrapped it up better than Ms. Leslie, is the issue of process. That when you're cutting people off from water because you say there's no water available